Okay, thank you. So we are here today, the House Judiciary Subcommittee on Family Law and the public hearing on House Bill 1397, which is Representative Sue Helm's bill. So we'll be having a lot of testimony on that, and I know Representative Helm has comments. Also like to introduce my co-chair here with I'm in the Senate today, I guess. In our House member, Representative Davis. Do you have any comments you'd like to share?
Not at this time, thank you.
And we also, as we have both our chairmen are here from the Judiciary Committee, so that is to be supportive of the bill and to hear the comments that we have. I'd also like to comment that we do have a very tight agenda, so those that are speaking, any summary that you can do, we do have all the testimony in front of us, word for word. So the comments that you make allows more time for questions, so the ability for us to get to the heart of the matter and the points that you guys want to make. We appreciate submitting all the testimony. We not only have testimony for those that are testifying here today, but also a fair amount of testimony that has been sent to the members of people that are concerned about the issue outside of those that we were able to have in today. We have, so the agenda is packed. So with that, we will introduce the prime sponsor of the bill, Representative Sue Helm. Come forward and make comments on your legislation.
Great group of people here this morning. I'm just like thrilled when I walked in this room and saw everyone here. But I would like to thank the Judiciary Chairman, Rob Kaufman, and Tim Briggs, and the chairwomen of the Subcommittee on Family Law, Cheryl Delosier and Tina Davis, for holding this hearing on House Bill 1397. House Bill 1397 would create the presumption that between 40 and 60% of a child's time should be spent with each parent. That is, that such an arrangement would be in the child's best interest. If a judge decides that it's not, and that certainly will happen, the judge must put down the reasons for that decision in writing. The other thing this bill does is more subtle. It changes the terminology and some of the language in existing law to move away from an assumption that one parent is better than the other, or that one parent is less fit. While this may not have an obviously legal effect, I believe it is important because it shifts the way we are asked to think about parents and their relationships with their children and with one another in this society. As a legislature, it seems that child custody is one of the issues that never goes away and is never easy. There is no simple answers, and it seems that often the very solution that would make the world right, again, for one family would create havoc for another. And also, while the legislature is tasked with creating policy, the judiciary is tasked with exercising a degree of discretion within the statutory framework. So the question becomes, how do we as legislators do the very best job we can while at the same time allowing judges to do the very best job that they can? As I said, there's no easy answers, but I look forward to hearing the perspectives and suggestions that will be presented here today. Thank you.
Thank you, Representative Helm. Before I call it the first testifier, Steve Meehan, if you want to move up, start moving up, and then, but also to mention that obviously I've talked to a number of people in my office as well on this bill. It is an emotional issue. It's a very personal issue for many people in this room, and I would simply just put out there, if we could please respect those that are testifying. We have differing views in this room, and both of them are important, and that's why we're having the hearing. So with the amount of people that are in this room, I would ask that let the speakers speak, and if you have something else to add, we can do that afterwards, but please respect those that are speaking in their opinions. So with that, Steve, I hand it over to you.
Good morning, and let's push. Check one. Does it seem to work? Whoops, is that working? Whoops. That's one way to do it. Check, there we go. Thank you so much. We are very grateful to be here today. My name is Stephen Meehan, and I actually was a former House staffer here on the Judiciary Committee and sat on the other side of the podium in a former life here. I am back before you today on an errand of love. I am serving as a volunteer chairman for the National Parents Organization. And around the nation, we have state affiliates that have been working with legislators and staff and are working to bring us closer to having a typical result being equal and shared parenting around the nation. We are grateful to my representative, State Helm, very proud to be in her district and proud that she has given our attention and allocated staff to help with this. I did want to mention that we are grateful to my close friend, Bruce Hanson, and the staffer that was assigned, Anna, to their help in drafting this very important bill. And I have to say, from the time that I spent in the legislature, this one is so very important. It is governing our most sacred bonds, and that is parent and child. Next to me, I have Mr. Matt Hale. He is from Kentucky, and in Kentucky, we did implement a similar bill, and we wanted to make sure you were aware of the results down there. So I will be referring to him. He did include some PowerPoint slides that we will get to. I'm going to be much more brief than my written testimony was submitted today, just to help move things along. I'm not here to discuss my personal case, but I am here to speak on behalf of families seeking child custody reforms. You will find me using the word "we," and that's not only the National Parents Organization, but that is all non-custodial parents, their family, their grown children who have been through our family law and courts. Today, we are here, and the laws that we've watched and have been normalized once upon a time included slavery. Once upon a time, there was a time when it was normal that women weren't allowed to vote. We've been through a lot, and unfortunately, we still have normalized some things that we believe should not be normalized, and I'm referring to the ease at which we designate non-custodial parents and create them. We would like to see the exception, which is about 15% of cases today in Pennsylvania, result in an equal shared parenting arrangement, and we believe that it should be reversed, and we believe that we would have a much healthier society and families if we get to that, and we believe that this bill will bring us closer to what should be normalized. There are some concerns that we have encountered in other states that came from bar associations and came from domestic violence industries. What I want to refer to next is the results from Kentucky, because we can address those concerns not by guessing, but by the actual results and the statistics of this act in Kentucky. And to that end, let me introduce Mr. Matt Hale, and he will inform us about the results of Kentucky.
Well, what a great day. Thank you to everyone on the committee for getting together and talking about what we can do to help children get to see both their parents after families separate. I'm Matt Hale, National Parents Organization Board of Directors member, but I am not here today as an advocate. I'm here today as a scout. I have walked the path that you are considering today. I initiated our nation's first shared parenting presumption law in Kentucky and led the effort for its passage. Kentucky's shared parenting law passed with enormous bipartisan support, 81-2 in the House and 38-0 in the Senate. The governor signed it into law, and then both parties tweeted out proudly about its passage. Kentucky joined together to do what's right for kids and pass a law that will one day be the law in every state, including Pennsylvania. After the lawmakers spoke so strongly with their votes, for the first time ever, American citizens got their say about an actual shared parenting law. And the voters spoke just as strongly, approving the legislation by a factor of almost 6-1 in polling. And what did the voters think of the lawmakers who passed the nation's first shared parenting presumption? They said 61% to 11% that they would support those lawmakers. And a few months later, the voters didn't speak, at the election, they roared. There's a chart in your packet there that shows the results from the Kentucky election, and it's a straight line for the sponsors. 100% of the sponsors won, 90% of the yes votes, 80% of those who abstained, and there weren't many who voted against, but you can see what their re-election result was. The law's popularity has grown even since then, with the state proclaiming the day it was signed as Shared Parenting Day forevermore. And the law will forevermore help Kentucky citizens. For instance, it's saving them money and lowering parental conflict. This is not a guess. The Administrative Office of the Courts issued an official report comparing domestic violence family court caseloads. And you can see the first year in that study is the year before the shared parenting law passed. The second year is when the temporary law portion of the law passed. And the third year is when the full-blown permanent custody law passed. And domestic violence cases went down. Fewer family cases means a lighter load on the judiciary, and that saves money. And that's the wonderful path that you're beginning now. Bipartisan unity, greater polling, happy voters, less parental conflict, and lower court costs. But the greatest step on the journey that you're undertaking right now will be the day that an alienated parent calls you with joy in their heart, saying that they get to see a child that they haven't seen in many years. And that's the real benefit of the walk you're taking. I have faith in everyone on this committee. You want what's best for your state's children, and that's the reason why you're considering shared parenting today. I look forward to taking this walk with you. Thank you.
So as it relates to scaling to Pennsylvania, just the math behind this, there are 48,000, between 46 and 48,000 cases of child custody that come in each year into our courthouses. As you know, we have 67 counties across the state, and you can imagine every day, as of today, we're producing thousands of cases over the course of a week that are resulting in non-custodial parents. That's a lot of voters. You can multiply that by 8 if you consider the 2 sets of grandparents, 2.5 children, the siblings, the aunts and uncles, the grandparents involved. That's a lot of people. That's a lot of people that are affected by one custody case. We must look at a custody case in terms of that. It's not just a mother versus a father. These are whole families involved. That math shows you over the course of a year how many people are deeply affected by this. When I walk around the Capitol and met with state representatives and their staff, all of them had told me that they personally have their family touched by this. So if you consider that math, this is a very significant issue, and it will affect a lot of people. And this is an issue that is very determinative. A voter will vote someone out or in based on this one issue. And you can tell from the room behind me that most of the people behind me are not just individuals, but they're also here representing larger communities and groups. There are too many to list. We've had Dr. Childress in before testifying in this room with a parallel approach to solving parental alienation, which is often a typical result when we assume that there is one primary parent and one lesser parent. It's only natural that people within your own family, your own children, see one as more important. One gets marginalized. And the statistics that result from that marginalization involve childhood traumas that we hear today. We hear today in the news a focus on the importance of not separating parents and children who are actually breaking the law coming across the border. And there is a great amount of concern for them being separated, while here in Pennsylvania we have 67 courthouses right now routinely separating or mitigating a parent's child and parent time. I haven't met the legislator yet who doesn't feel uneasy about the prospect that if their marriage fails, that they will go before someone that they don't know that well, who just got elected, and will tell you when you can love and see your children. It's the most basic bond. We need to have a more predictable outcome. There was testimony on another House bill in judiciary that regarded grandparents' rights, and we wanted to create a law with more certainty. The testifier said we want our society to have some level of predictability that our bio-grandparents and that our parents will be involved naturally and as to be expected, a presumption of their relevance in the life, and we ask that we afford parents that same predictability. It will reduce conflict, it will reduce trauma on the children, and it has proven to reduce violence. We are not asking that we, at this time, change anything with regards to any kind of criminal behavior that was involved or convictions. That's still there, it's unchanged. This bill would not change that. But we would ask you to try and take this small step forward so that we normalize parental involvement and equality and render the 15% being the sole custody, and at least require our judges to give a factually based rationale for not awarding that. And that's what we're here for today, and we're very grateful once again for this committee's attention to this issue. We know that it's a long one, it's a very passionate one, and we hope that you will continue to seek more information and results as it is occurring. I believe it was just introduced in Florida the other day as well. It is going to become more normalized and more expected that we find a way to split custody more equally. Anything to add, Matt? No. Okay.
Thank you very much for your testimony, and at this point, there are no questions, so I appreciate your time and effort and the information that you shared with us.
Thank you.